Prayers. I will invite the Honourable Minister of Commerce to grace us with prayers.
Let us pray. Almighty God, from whom all wisdom and power are derived, we beseech thee so to direct and prosper the deliberations of the Legislative Assembly now assembled, that all things may be ordered upon the best and surest foundations for the glory of thy name and for the safety, honor, and welfare of the people of these islands. Bless our Sovereign Lady, Queen Elizabeth II, Philip, Duke of Edinburgh, Charles, Prince of Wales, and all the royal family. Give grace to all who exercise authority in our Commonwealth, that peace and happiness, truth and justice, religion and piety may be established among us. Especially we pray for the Governor of the Cayman Islands, the Premier, the Speaker of the Legislative Assembly, the Leader of the Opposition, Ministers of the Cabinet, ex officio members, members of the Legislative Assembly, and the Chief Justice and members of the Judiciary, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for thy great name's sake. Let us say the Lord's Prayer together. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. The Lord bless us and keep us. The Lord make his face shine upon us and be gracious unto us. The Lord lift up the light of his countenance upon us and give us peace now and always. Amen.
Please be seated. Proceedings are resumed.
Administration of oaths or affirmations.
None.
Reading by the Honourable Speaker of messages and announcements.
None.
Presentation of petitions.
None.
Presentation of papers and of reports. The government minute. The government minutes. The government's response to the reports of the Standing Public Accounts Committee on the reports of the Auditor General, to be laid on the table by the Honourable Premier.
Honourable Premier.
Thank you, Madam Speaker. Madam Speaker, in accordance with Section 77, subsection 7 of the Legislative Assembly Standing Orders 2006 revision, I beg leave to table the government minute on the report of the Standing Public Accounts Committee on the Office of the Auditor General's report entitled Fighting Corruption in the Cayman Islands.
So ordered. Does the Honourable Premier wish to speak thereto?
Yes, thank you, Madam Speaker. Madam Speaker, the government minute contains the responses and views of the government, along with progress updates on the recommendations contained in the report of the Public Accounts Committee, as well as the recommendations of the Auditor General's report. I have said on many occasions that this government is committed to transparency and accountability, and we expect the entire elected government and the public service to share our commitment to eliminating corruption in the Cayman Islands. I believe this commitment is reflected in what has been achieved in this regard, some of which is captured in the government minute that I have just tabled. I would like to take this opportunity to highlight some of the progress that the government has made on the implementation of the various recommendations in the Public Accounts Committee's report. Members of this Honorable House will be aware that the Standards in Public Life Law is now in force. On the 25th of February this year, His Excellency the Governor signed the commencement order for the Standards in Public Life Law 2015 and the Standards in Public Life Amendment Law 2016, as well as the Standards in Public Life Regulations 2020. The Standards in Public Life Commission, supported by the Commission Secretariat, has been working to fully implement the provisions of these important legislative instruments. The Office of the Deputy Governor has engaged with key stakeholder agencies regarding the Office of the Auditor General's recommendation that government consider extending the list of designated authorities to whom whistleblowers can turn, and has identified that there is no current restriction on where an individual can go to make a disclosure of improper conduct, and that a non-designated authority can ensure whistleblower protections for an individual by arranging for the whistleblower to make the disclosure to the Ombudsman. Notwithstanding this protection currently exists, Madam Speaker, it is worth noting that the Office of the Ombudsman plans to undertake a wider review of the whistleblower protection law commencing later this year, and this recommendation from the Auditor General will be considered in more detail as part of that review. With regard to the recommendation that a single owner of the anti-fraud policy be identified, I can report that the Accountant General has been given that role and is responsible for ensuring that the anti-fraud policy is updated on a regular basis, and these updates are communicated to the civil service. In January last year, pursuant to Section 49D of the Public Authorities Law, Cabinet extended the anti-fraud policy to the statutory authorities and government-owned companies which did not already have their own fit-for-purpose anti-fraud policies. As a result, Madam Speaker, every public service agency is now required to have, and in fact should have, an anti-fraud policy in place. As recommended by the Auditor General in her report, the Minister of Finance and the portfolio of the Civil Service have committed to ensuring that the anti-fraud training is completed by all civil servants and that updated training is done on a regular basis. They are working towards a target of having all existing civil servants who have not yet completed the anti-fraud training to have done so by the 31st of December this year. The portfolio of the Civil Service has also been working to incorporate the anti-fraud training as part of the mandatory new hire orientation sessions, which is in keeping with a recommendation in the Public Accounts Committee report. And this will help to ensure that the civil servants are made aware of the anti-fraud policy and its importance from the very start of their civil service tenure. An important development in our governance framework, Madam Speaker, was the establishment of the Audit, Risk and Assurance Committee under the Office of the Deputy Governor. This committee provides the Deputy Governor with independent and objective advice on the comprehensiveness, reliability, and integrity of assurances on governance, risk management, and control for the Cayman Islands core government. The Audit, Risk and Assurance Committee started meeting in mid-2019 and has continued to meet on a quarterly basis through 2020. Madam Speaker, a number of the recommendations in the Public Accounts Committee's report were for action by the Department of Planning. I am pleased to report that significant progress has been made there as well. The department has adopted anti-fraud policy, and all Department of Planning employees are required to complete and file notice of interest forms on an annual basis, with updates submitted as necessary through the Ministry's electronic portal. The members of the Central Planning Authority and the Development Control Board are required to file a declaration of interest annually, and these are available for public inspection through the Department of Planning's website. The Director of Planning also ensures that any potential board member conflicts with listed agenda items are declared at the start of each meeting of the CPA and the Development Control Board, and these declared conflicts are appropriately recorded in the minutes of the meeting. In closing, Madam Speaker, I want to thank my colleagues in this Honourable House and the members of the Public Service for their efforts towards fighting corruption in the Cayman Islands. It can sometimes be a difficult path, but there can be no doubt that it is simply the right thing to do. I am heartened by the commitment of everyone involved to make sure we stay the path and put the necessary measures in place to ensure the people of the Cayman Islands can continue to have confidence in the integrity of the elected government and the public service. Thank you for the opportunity, Madam Speaker, to table this government minute and to highlight some of the progress that this government has made in this important area. I invite members of this Honourable House to review the government minute in detail.
Cayman Islands Government Plan and Estimates, Second Supplementary Plan and Estimates for the financial year 1st of January to 31st of December 2018. Cayman Islands Government Plan and Estimates, First Supplementary Plan and Estimates for the financial year 1st of January to 31st of December 2019, to be laid on the table by the Honourable Minister of Finance and Economic Development.
Honourable Minister of Finance.
Thank you, Madam Speaker. Madam Speaker, I beg to lay on the table of this Honourable House the second supplementary plan and estimates for the Government of the Cayman Islands for the financial year ended 31st of December 2018.
So ordered. Does the Honourable Minister wish to speak thereto?
Thank you, Madam Speaker. Very briefly, Madam Speaker, in accordance with Standing Order 67-1, the second supplementary plan and estimates document that has just been tabled now stands referred to the Finance Committee. As the estimates will be considered in Finance Committee at the conclusion of this meeting, at the conclusion of the second reading of the associated supplementary appropriation bill that is further down on the order paper, I wish only to make brief remarks with respect to the tabled document. Madam Speaker, the second supplementary plan and estimates document that has just been tabled is structured in the following way. Section A of the document shows it in respect of the specific appropriation being changed the following information: the amount of the original approved appropriation for a particular budget item, the amount of the supplementary appropriation proposed for the particular budget item, and the revised appropriation amount for the particular budget item. Section B of the document contains the proposed changes to the appropriation law for the financial year ended the 31st of December 2018, and that law was approved by the Legislative Assembly in November 2017. And Section C of the document shows the financial statements for the financial year ended the 31st of December 2018. Madam Speaker, honourable members should use the second supplementary plan and estimates as a document that provides more information to each of the items in the schedule to the Supplementary Appropriation Bill for the 2018 financial year, and that bill will appear further down in the order paper. The schedule contains items of supplementary appropriations with respect to the period for the 1st of November 2018 to the 31st of December 2018. Thank you, Madam Speaker.
Questions to honourable ministers and members of the Cabinet?
None.
Statements by the honourable ministers and members of the Cabinet.
Sorry, Madam Chair, I do have a second document that needs to be tabled as well, if I could. It's a supplementary expenditure, supplementary plan for 2019. My apologies.
Okay, please proceed, Honourable Minister of Finance.
Thank you, Madam Speaker. I beg to lay on the table of this Honourable House the first supplementary plan and estimates for the government for the Cayman Islands for the year ended 31st of December 2019.
So ordered. Does the Honourable Minister of Finance wish to speak thereto?
Again, very briefly, Madam Speaker, I thank you. And in accordance with standing orders, this supplementary plan and estimates document that has been tabled, it now stands referred to Finance Committee. As the estimates will be considered again in Finance Committee at the conclusion of the second reading of the supplementary bill, that is, I wish to make only brief remarks with regard to the tabled document. Madam Speaker, similarly with the document I previously tabled, the supplementary plan and estimates for 2019 is structured in the following way. Section A shows in respect to the specific appropriations being changed the following information: the amount of the original approved appropriation, the amount of the supplementary appropriation, and the revised appropriation amount for the particular budget item. Section B also contains the proposed changes to the appropriation law for the financial year 2019, and that law was approved in the Legislative Assembly in November 2017. Section C of the document shows the unaudited financial statements for the financial year ended 2019. Madam Speaker, the honourable members should use this supplementary plan and estimates as a document that provides more information to each of the items in the schedule to the supplementary appropriation bill for the 2019 financial year. And the schedule contains items of supplementary appropriations with respect to the period for the 1st of January to the 31st of December 2019. Thank you, Madam Speaker.
Sorry, questions to the honourable ministers and members of the Cabinet?
None.
Statements by the honourable ministers and members of the Cabinet.
Honourable Minister of Finance.
Thank you, Madam Speaker. Madam Speaker, as required by Section 11(6) of the Public Management and Finance Law 2020 revision, or the PMFL, I rise this morning to make this statement to members of this Honourable House with respect to the exceptional circumstance transactions that were approved by Cabinet for the Ministry of Finance and Economic Development during the 2019 financial year that ended on the 31st of December 2019. Such transactions were approved pursuant to Section 11.5 of the PMFL. Madam Speaker, this statement provides details of the aforementioned transactions. First, transfer of Customs and Border Control to the Ministry of Employment and Border Control. Madam Speaker, on the 1st of February 2019, as this Honourable House is aware, the Customs Department was transferred from the ambit of the Ministry of Finance and Economic Development to the Ministry of Employment and Border Control. The administrative procedures for transferring a department to another ministry, Madam Speaker, includes the transfer of output groups and appropriation amounts which are related to the department. In the case of the transfer of the Customs Department, the output groups and appropriation amounts that were transferred were equivalent to 11 months of appropriated funding as Customs was transferred on the 1st of February 2019. The amounts transferred from the Ministry of Finance's 2019 appropriations include $273,665 from FED1 Policy Advice and Ministerial Services, $165,747 from FED2 Governance and Administrative Services, $1,422,518 from FED3 Collection of Coercive Revenue, $7,095,211 from FED6 Processing of Passengers and Inspection of Aircraft, Vessels, and Cargo, and $2,377,445 from FED7 Identification and Investigation of Customs Offenses. Second, unspent funds used for other capital projects and programs and for the cost of the 2018 post-retirement healthcare accounting valuations. Madam Speaker, it is common during each financial year that the government undertakes an exercise to reprioritize and assess the progress of its capital projects and programs and identify savings within the budget which can be reallocated to other areas of expenditure where there is a shortfall in funding. During the 2019 financial year, the Ministry of Finance assessed its own capital projects and found that it was not going to utilize all of the funding that was approved for the implementation of the retail management system at the Cayman Islands Postal Services. Instead of allowing the unspent funds to lapse at the end of 2019 financial year, the Ministry of Finance was able to offer up $249,000 in unspent funds from EI-70, Ministry of Finance and Economic Development. Madam Speaker, the transfer of the unspent funds is evidenced by the reduction to EI-70, Ministry of Finance and Economic Development, by $249,000. The government's accounting standards, International Public Sector Accounting Standards, or IPSAS, requires the government to disclose in its financial statements the value of employees' post-retirement healthcare pension benefits. The cost for the post-retirement healthcare and pension valuations, which are normally sourced by the Public Service Pension Board, was not included in the Ministry's initial 2019 budget. Instead of seeking supplementary funding, the Ministry of Finance used $80,000 in unspent funds in EI-70, equity investment in the Ministry of Finance, to pay for the unbudgeted cost of the valuations. This is evidenced by an increase of $80,000 to FED5, Financial Reporting and Management Services, the appropriation where the cost of the valuations were paid. Madam Speaker, the $169,000 balance of unspent funds in EI-70 equity investment in the Ministry of Finance was used to help other agencies in government to support their capital projects and programs that required additional funding. The net position is that there is no overall increase in expenditure arising from the aforementioned matters. Third, increase in health insurance premiums. Madam Speaker, for a number of years, government has underpaid the actuarial premium rates for civil servants, civil servant pensioners, seafarers, and veterans. This practice of premium discounting contributed to a number of issues for Synico, including large operational losses and Synico falling below the prescribed capital requirement as mandated by Insurance Capital and Insolvency Class A Insurers Regulations 2012 of CIMA. Commencing in 2019, government committed to paying the full actuarial premium rates for civil servants, civil servant pensioners, seafarers, and veterans, which cost the government an additional $14.4 million in 2019. This $14.4 million is made up of an initial $5.6 million that was approved by the Legislative Assembly and placed in the Appropriation Law for the 2019 financial year, and a further $8.8 million was approved by Finance Committee in 2019. Madam Speaker, the $14.4 million was placed centrally within the Ministry of Finance's OE18 increase in health insurance premiums for civil servants appropriation, and then the Supplementary Appropriation Bill for 2019 financial year, which the House will consider during this meeting of the Legislative Assembly, reallocates this total $14.4 million across all the various output groups in ministries, portfolios, and offices. The Supplementary Appropriation Bill for 2019 financial year reflects a 2019 in-year change to OE18 of a negative $5.6 million, reflecting the fact that although $8.8 million was added to OE18 in April 2019, $14.4 million is to be removed from OE118 and reallocated to output groups across ministries, portfolios, and offices. Thus, the negative $5.6 million in-year movement in OE118 and its positive $5.6 million appropriation amount at the 1st of January 2019 means that its net balance at the end of the 31st of December 2019 was zero. Madam Speaker, the reallocation of the $14.4 million of additional health insurance premiums in 2019 is evidenced by a series of increases to the various output groups across ministries, portfolios, and offices that are shown on pages 21 to 33 in the 2019 Supplementary Appropriation Bill that the House will consider at this meeting. The increased health insurance cost, which was reallocated to the Ministry of Finance, is demonstrated by an increase in FED1 for policy advice and ministerial services by $34,130, an increase to FED2 governance and administrative services by $2,672, an increase to FED3 collection of coercive revenue by $48,082, an increase to FED4 preparation and publication of statistical reports by $23,960, an increase to FED5 financial reporting and management services by $74,735, an increase to FED6 processing of passengers and inspection of aircraft, vessels, and cargoes by $193,791, an increase to FED7 identification and investigations of customs offenses by $40,431, and an increase to FED9 administration and processing of applications by $6,288, an increase to FED10 national mail service by $131,541, an increase to FED11 monitoring and reporting on the economy by $4,554, and an increase in CIN1 health insurance for seamen and veterans for primary and secondary health care by $1,319,130. Madam Speaker, the aforementioned exceptional circumstance transactions, which were approved by Cabinet for the Ministry of Finance and Economic Development during the 2019 financial year, did not cause any non-compliance with the principles of responsible financial management. Thank you, Madam Speaker.
I have given leave to the Honorable Deputy Governor to make a statement. Honorable Deputy Governor.
Thank you, Madam Speaker. Madam Speaker, as required by Section 11(6) of the Public Management and Finance Law, 2018 revision, the PMFL, I make this statement to the members of this Honorable House with respect to the exceptional circumstances transactions that were approved by the Cabinet for the portfolio of the Civil Service during 2019, covering the period 1st of January to 31st of December 2019. Such transactions were approved pursuant to Section 11(5) of the Public Management and Finance Law. Madam Speaker, this statement provides details of the aforementioned transactions. $1,320,000 to CV13, maintenance of the electoral register for the People's Initiated Referendum process. Madam Speaker, this Honorable House will be aware that the organizers of the Cruise Port referendum movement presented the Supervisor of Elections and the head of the Governor's office a petition which purported to contain a total number of signatures exceeding 5,289, or more than 25% of the registered electors pursuant to Section 72A of the Cayman Islands Constitutional Order 2009. The Elections Office began the verification process, inclusive of walk-ins at the Elections Office, verification at various locations such as supermarkets, and in-person verification at home and other venues. The Election Office accelerated the mobilization of the personnel needed to perform the verification process with an aim of completing the same by mid-August 2019. Work progressed with early preparation of the referendum training, materials, and logistical plans in the event that a referendum progressed. As 2019 was a non-election year, the 2019 Elections Office budget of $407,821 represented a fraction of the sum needed to host an election or a referendum. By comparison, the 2017 general election was delivered with an approved budget of $1.98 million. The cost associated with conducting a national poll totals some $1.2 million, inclusive of increased promotion of voter registration, voter education, security training, equipment, transportation, real estate, personnel, and materials. Madam Speaker, in the absence of an existing appropriation adequate to cover costs related to the People's Initiated Referendum process, a supplementary appropriation was required to allow the Elections Office to carry out its constitutional responsibilities and duties. In the event that a referendum was triggered, the polling exercise would have required some 500 persons to be deployed in polling activities while being supported by logistics and the RCIPS for security. Madam Speaker, having outlined these details, the Elections Office sought approval for an appropriation for the following: costs associated with the Cruise Port petition signature verification process and prep work for a referendum, which was projected to total some Cayman Islands dollars 220,000, and projected cost of Cayman Islands dollars $1.1 million associated with national polling for a referendum, inclusive of postal ballots, mobile voting, and general polling on referendum day, contingent on the outcome of the verification process. Madam Speaker, note that without the additional funding, the Elections Office would not have been able to meet its constitutional obligations, opening the office and the Cayman Islands government to potential legal action for breach of law. Madam Speaker, an additional $1,350,000 to CIN2 health insurance for civil service pensioners. Madam Speaker, the portfolio of the Civil Service carries the appropriation for executive expenditure related to CIN2 health insurance for pensioners. The 2019 budget for CIN2 was $22.5 million. The actual cost for 2019 totaled $27.4 million. signifying a budget shortfall of $4.9 million. I will now outline for this Honorable House some general numbers to demonstrate the impact of the premium increases during the 2018-2019 budget cycle. There was a net increase of 31 or 1% of the total insured. Those persons over the age of 60 increased by 3% to 57. As of December 2019, the total insured was 2,243. During the stated period, the highest monthly premium being charged was $1,288. Compare this to the just prior to the 2018-2019 budget, where there was a total insured of 2,212, and the highest premium was $958. Madam Speaker, this means that the highest premium increased by 34%, or $330 per month during that period of time. The monthly invoices paid by the POCS for CN2 previously averaged $1.7 million per month, but in 2019 it increased to an average of $2.27 million per month. In previous years, the portfolio of the Civil Service was allocated additional supplementary funding for the increases in the health insurance premiums for CIN2. This was done via a centralized reallocation managed by the Ministry of Finance. However, the reallocated amount of $3.57 million provided in the 2019 iteration was insufficient to cover the total increases of the premiums related to CIN2. As a result, the POCS had to seek an additional $1.35 million to cover the remaining shortfall. Conclusion, Madam Speaker, the aforementioned exceptional circumstance transactions, which were approved by the Cabinet for the portfolio of the Civil Service during the 2019 financial period, did not cause any non-compliance with the principles of responsible financial management. Thank you, Madam Speaker.
Honorable Leader of the Opposition.
Thank you, Madam Speaker. Madam Speaker, in accordance with Standing Orders 32, I would ask your indulgence to ask the Deputy Governor a few short questions.
Please proceed, Honorable Leader of the Opposition.
Thank you, Madam Speaker. Madam Speaker, I guess it's asking some clarification. Health insurance for civil service pensioners, is that carried by Seneco in all instances?
Honorable Deputy Governor.
Madam Speaker, could a member please repeat the question? Sorry, I didn't hear it.
Sorry about
Honorable
that,
Leader of the Opposition.
Madam Speaker. I'm wondering if civil service pensioners insurance is carried by Seneco in all instances.
Honorable Deputy Governor.
Thank you, Madam Speaker. Yes, Madam Speaker, to the best of my knowledge, all of the persons who I just spoke to about the civil service pensioners are covered by Seneco.
Honorable Leader of the Opposition.
Thank you, Madam Speaker. I expect he knows the next question. Has this increase come, the 3%, and the increase in costs come as a result of some of the statutory authorities having people retired and now transferring into Seneca?
Honorable Deputy Governor.
Madam Speaker, thank you. Madam Speaker, there was a number of factors that caused the increase, which I stated in the statement. Is the member saying that people retired from? I'm not following what he's saying. I mean, we're only covering people here. The people that I'm talking about here are retired pensioners. are persons who are retired and are receiving their pension from the government. So they would have been employed by the government, by the wider public service.
Honourable Leader of the
Thank you,
Opposition.
Madam Speaker. Madam Speaker, if you say the wider public service, does that include SAGS and SAGC and other entities as well? Because I understand us to distinguish the difference between core government and the other entities, statutory authorities and whatnot.
Honourable Deputy Governor.
Madam Speaker, before the Deputy Governor responds, he may want
Honourable Leader of the Opposition.
to try and, maybe I'm not explaining myself good enough. We had occasion here recently to hear from some statutory authorities who say that once their people retire, they then have to go and seek insurance from Seneco or someone else because they, prior to retiring, the statutory authorities many years ago, moved their staff from government, under government insurance over to private insurance. So I'm wondering if some of these are those who have now migrated over into Seneco.
Honourable Deputy Governor.
Madam Speaker, I just want to thank the FS for giving me some additional clarification as well. So, Madam Speaker, that could be the case, but that's a very small number. The main driver for these increases is because in previous years, we were not paying the actuarial numbers, or in other words, the true cost of the premium, and that is now what we are doing. We are paying the exact cost put to us by Seneco.
Honourable Leader of the Opposition.
Thank you, Madam Speaker. Madam Speaker, I need to realize the Deputy Governor this. And in the transition of government bodies into statutory authorities and companies and entities, there has always been that provision for that they should be no worse off, put in those laws that governs them. The advent of so many staff members, and I can speak of one in particular, Cayman Airways, that we were told that they have no insurance once they retire. What are we going to do about that?
Honourable Deputy Governor.
Yes. Madam Speaker, this issue has begun to really rise its head for the last couple of months. Madam Speaker, it's important that the statutory authorities make provisions for health care for their employees. It's really not fair for persons to be working for the sort of public service, and then when they retire, says, okay, the civil service, you now need to start paying my health insurance premiums. You were not employed by central government. So it is basically incumbent on those statutory authorities to start to accrue for the health service liability for their staff when they retire. That is something for the individual statutory authorities to look into. it is something that we can have a wider conversation with in terms of something being done under the Public Authorities Law, and we're happy to have that conversation. But for right now, Madam Speaker, I think it's real responsibility for those statutory authorities and government-owned companies to look to making provisions for their employees the same way that the central government has for theirs.
I have given leave to the Honorable Attorney General to make a statement. Honorable Attorney General.
Thank you, Madam Speaker. Madam Speaker, can I apologize for the late notice for the statement? Madam Speaker, pursuant to Section 11.6 of the Public Management and Finance Law 2018 revision, I wish to make a statement to members of this Honorable House regarding exceptional circumstances which were approved by the Cabinet for the portfolio of legal affairs during the 2018-2019 financial years that ended on the 31st of December 2018, 31st of December 2019, respectively. Madam Speaker, the exceptional circumstances required making changes to the 2018 and 2019 appropriations, which I will briefly explain. There are several factors, Madam Speaker, impacting judicial administration's 2018 executive budget, thus requiring the need to seek supplemental funds for appropriations, OE1, personnel emoluments, for the judiciary, OE4, judiciary expenses, and OE65, Court of Appeal expenses. These factors, Madam Speaker, include 1, appointment of new judge due to the increased demand of the Financial Services Division, referred to as the FSD. There was a need for one of our permanent FSD judges to be on Ireland full-time. The Governor agreed to the terms of a sitting FSD judge's contract to enable him to relocate to the Cayman Islands and to be employed, Madam Speaker, on a salaried and pensionable basis. The additional funding required would impact both the 2018 and 2019 financial years. Enhancement of employment benefits is the other factor, Madam Speaker. Enhancement of employment benefits available to magistrates, and this was because there was an enactment of the Judges' Emoluments and Allowances Law 2018 revision and the Judges' Emoluments and Allowances Amendment Order 2018. This law retroactively altered the salary and benefits of magistrates from January 2016. Although some monies had been included in the budget to manage these costs, additional funds was required as the final agreement on the terms of the benefits were not finalized until 2018. The additional funding required would impact both the 2018 and 2019 financial years. 3, additional permanent magistrates. The increased sitting of acting magistrates to almost a full-time basis justified the need to introduce 2 additional permanent magistrates posts. At the beginning of 2018, there were 3 full-time magistrates and 4 acting magistrates. With the creation of 2 additional permanent magistrates posts, the acting magistrates complement will reduce from 4 to 2. The conversion of these 2 posts would impact the 2018 and 2019 budgets of judicial administration. 4, the Court of Appeal uplift. Due to the disparity of emoluments between Court of Appeal judges and Grand Court acting judges, Her Excellency, the Governor, Helen Kilpatrick, agreed to equalize the remuneration and benefits of the Court of Appeal judges. Her Excellency signed an amendment to the employment agreements of all Court of Appeal judges on 6th of February 2018. This, Madam Speaker, required an uplift to their daily rate to be on par with that of the acting judges, and also to ensure that the cost of living adjustment that they are entitled to under the law is carried out at the same time as that of the Grand Court judges, to ensure there is no further disparity between the rates. The uplift would require additional funding in both 2018 and 2019 financial years. 5, Court of Appeal increased sitting. Due to the increased number of appeals, there was a demand for additional Court of Appeal sittings. 1 additional Court of Appeal sitting was needed in 2018, and 2 additional sittings planned in 2019, thus requiring additional funding. 6, actual higher than budget. The actual cost of living adjustments payable to judges and magistrates was higher than budgeted, thus impacting the 2018 and 2019 budget. Also, the demand for services for visiting/acting judges was higher in 2018 than originally budgeted. The additional funding required in 2018 totaled $1,517,265. Internal savings of $750,000 were identified within Judicial Administration's 2018 appropriations. Further savings of $767,265 were identified within the portfolio of legal affairs and reallocated to cover the full anticipated cost. The following changes were approved by Cabinet via Section 11.5, Madam Speaker. A, increase appropriations. OE1, personnel emoluments for the judiciary in the amount of $502,796. OE4, judiciary expenses in the amount of $473,437. OE65, Court of Appeal expenses in the amount of $541,032. Total appropriation increase, $1,517,265. B, decrease appropriations. JAD1, administrative support to the judiciary, $112,500. JAD2, support for the court proceedings, $337,500. EA145, courthouse, $300,000. LGA1, legal advice and representation in civil matters, $400,000. LGA7, review and modernization of laws, $150,000. LGA4, drafting of legislation and regulations, $130,000. LGA3, law teaching and publications, $87,265. Total appropriation decrease, $1,517,265. The 2019 additional funding required for the aforementioned items was approved at Finance Committee during the April 2019 sitting of the LA via Section 12. The increase to appropriation are as follows, Madam Speaker. OE1, personnel emoluments for the judiciary in the amount of $847,052. OE65, Court of Appeal expenses in the amount of $688,014. In 2019, additional funding was also requested and approved at Finance Committee in April 2019 via Section 12 to cover the operational costs such as utilities and janitorial for the then recently purchased Old Scotia building. The increase in appropriation was to JAD2, support for court proceedings, $372,000. Also, Madam Speaker, in 2019, Cabinet approved the reallocation of funding held with the Ministry of Finance and Economic Development to each of the ministries, portfolios, and offices for the increase in health insurance premiums for civil servants. The Ministry of Finance centrally budgeted for the increase, and once the increased premium rate was determined, transferred the funding accordingly. As a result, the following appropriation increased. JAD1, administrative support for the judiciary, $16,909. JAD2, support for court proceedings, $51,268. JAD3, collection of revenue, $6,283. JAD4, financial management of court funds, $3,102. And OE1, personal emoluments for the judiciary, $27,258. In conclusion, Madam Speaker, the above exceptional circumstances which were approved by the Cabinet for Judicial Administration during 2018-2019 financial years, along with the overall effect on the government's compliance with the principles of responsible financial management, can be found in the 2018-2019 supplementary plan and estimates tabled in this honorable House. I thank you, Madam Speaker.
Personal explanations,
None.
obituary and other ceremonial speeches,
None.
raising a matter of privileges,
None.
government business, bills. First readings, Domestic Partnership Bill 2020.
The bill has been deemed to have been read a first time and is set down for second reading.
Supplementary Appropriation, January 2018 to December 2018, Bill 2020.
The bill has been deemed to have been read a first time and is set down for second reading.
Supplementary Appropriation, January 2019 to December 2019, Bill 2020.
The bill has been deemed to have been read a first time and is set down for second reading.
Second reading, Domestic Partnership Bill 2020.
Honorable Premier.
Thank you, Madam Speaker. Madam Speaker, I beg to move the second reading of a bill for a law to provide for domestic partnership and for incidental and connected purposes.
The bill has been duly moved. Does the mover wish to speak thereto?
Thank you, Madam Speaker. Madam Speaker, the bill before the House this morning is one that I think all of us would have to agree the most contentious issue, addresses the most contentious issue that I certainly have known since I arrived in this House almost 20 years ago. And so, Madam Speaker, it is with a great deal of deliberation, thought, and prayer that we have arrived at this point, and that I discharge the solemn obligation of moving the Domestic Partnership Bill 2020 and introducing it to this House. Madam Speaker, to say the bill is contentious is an understatement. But it is a very important bill. There are those in the public who support it as it has been published. There are those who support it but say it doesn't go far enough. There are even those opposed to it because it does not go far enough, in their view. And then there are those who oppose it outright for varied reasons, including religious grounds. And because of that, we can expect heated and spirited debate inside and outside these chambers for and against the bill. But, Madam Speaker, I would urge us all, as we speak our mind and our conscience, to remember always the importance of compassion and tolerance, and to understand that however strongly our views may be held, others are entitled to theirs as well. And that, Madam Speaker, it is other people, other parents' children, others' children's parents that we are speaking about. My point, Madam Speaker, we are all God's creatures, and we ought, Madam Speaker, regardless of how strongly we feel about an issue like this, to remember that. Madam Speaker, let me now seek to describe what the bill seeks to do. In broad terms, the bill contemplates two persons entering into a domestic partnership which is registered by a registrar of domestic partnership. Those registering must be 18 years or older, or if between 16 and 18 years old, they must have the requisite consent of parents, guardians, or the courts, in the same way that consent is necessary if two persons of opposite sex propose to marry under the age of 18. Neither person can, at the time of registration, be married or in a recognized domestic partnership. And of course, Madam Speaker, they cannot be related. In short, Madam Speaker, if the bill, if it becomes law, will permit two adults to enter into a formal legal partnership with defined rights recognized by the state. It will be termed a domestic partnership. It is not a marriage. That is what this bill is about, Madam Speaker. But before I get into the details, I would like to say a few things about what the bill is not about. First, this is not a bill about the legality or morality of homosexuality. The issue of the legality of homosexuality in these islands has been settled for almost 20 years now, as required under the United Kingdom's Caribbean Territories Criminal Law Order 2000. That is an order in council made by Her Majesty in Privy Council, which took effect on the 1st of January 2001. That act, Madam Speaker, as I said, passed in the UK by order in council, decriminalized homosexuality in these islands and indeed all of the overseas territories, and confirmed that homosexual acts carried out in private shall not be an offense, provided that the parties consent thereto. And so, Madam Speaker, regardless of our views about homosexuality, that has been the position in our islands for almost 20 years. Homosexuality is not a criminal offense. Despite that, Madam Speaker, when issues such as the one now before us are raised, often what we hear are thunderous speeches railing against homosexuality. Madam Speaker, I do not for a moment doubt the sincerity of the views held by many in these islands on this subject. However, I do question the relevance of such views when it comes to the matter before us today and the issues contained in this bill. Madam Speaker, there is a very important principle at stake here today. But the rights and wrongs of particular lifestyles is not it. Rather, as I will explain, the principle at stake today, and with this bill, is whether this Honorable Legislative Assembly of the Cayman Islands is willing to uphold the rule of law. In my view, for lawmakers, principles do not come much more important than that. And I hope members will focus their minds on it as we deliberate here today. The late President of the United States, John F. Kennedy, in his message to the American people in 1962 on discrimination, is one that it is appropriate for this House to consider on this occasion. The late President noted that while citizens are free to disagree with the law, they are not free to disobey it. Secondly, Madam Speaker, this is not a bill about marriage, specifically marriage between same-sex couples. We have sought in bringing this bill to ensure that we maintain what our law says about marriage, and also the views of many in our church communities. But we have also acknowledged the need to abide by the law and to provide protections for same-sex couples that the law and the courts have demanded of us. Madam Speaker, I was heartened to receive a letter on the 16th of July from the Cayman Ministers Association, where they recognized the efforts that we have gone through to protect the rights of people on both sides of the debate. Madam Speaker, the letter, with your permission, I will read. Dear Honorable Premier, greetings. I write on behalf of the Cayman Ministers Association regarding the Domestic Partnership Bill. We do appreciate the cordiality and consideration that both yourself and the Attorney General have always afforded us. We also sincerely appreciate your sensitivity to the concerns of the church and wider community regarding same-sex relationships. You did express, however, the need to address the lingering matter of same-sex unions, especially in the light of the ruling of the Court of Appeal. We, as a Cayman Ministers Association executive, are further appreciative of the manner in which you sought to protect heterosexual marriage according to our Constitution, and also to protect marriage officers and churches from any obligation regarding domestic partnerships. We do wish to submit very humbly and respectfully a formal position letter which we would like you to consider in your decision-making. This we also would be making available to the other members of the Legislative Assembly. Attached also are comments from the Right Honorable Dame Joan Sawyer, former President of the Court of Appeal and Chief Justice of the Bahamas. We know this is a very difficult matter, and may God grant you wisdom in your decision-making. Yours very truly, Torrance Bob, Chairman, Cayman Ministers Association. Madam Speaker, with your permission, I would like to lay a copy of that letter on the table of this Honorable House.
So allowed, Honorable Premier.
Madam Speaker, I will make available a copy of this letter and attachments to all members of this Honorable House, although I believe many of them may have received it themselves. The letter, Madam Speaker, from the Cayman Ministers Association speaks well to their recognition of our efforts to keep marriage and domestic partnerships separate. So, Madam Speaker, I say again that this bill is not about marriage. This point, Madam Speaker, is very important, and I will say more about it shortly. But before doing so, I need to remind the House of the background to this bill. The particular path that has brought us here is a complaint by Ms. Chantel Day, a Caymanian attorney, and Ms. Vicky Borden Bush. A complaint that has been considered by the highest court in our land. What the courts, both the Grand Court and the Court of Appeal, have determined lies behind that complaint is the failure over many years of this Honorable House to provide a solution that safeguards the rights of some members of our society. It is that failure we are being charged to rectify here today. In April 2018, Ms. Day and Ms. Bodenbush wrote to the General Registry requesting a license to enter into marriage in the Cayman Islands. The application was properly refused, given the clear requirements of our marriage law, which stipulates in Section 2 that marriage is the union between a man and a woman as husband and wife. Therefore, Madam Speaker, as a matter of law, the General Registry could not properly and did not issue a license to them to get married. That was the law then in August 2018, and that is the law today in July 2020. Madam Speaker, more importantly, that will remain the law even if this bill is passed by this House. This bill does not seek to change or supersede the existing marriage law. Madam Speaker, having properly met with a refusal by the General Registry, Ms. Day and Ms. Bodenbush applied to the Grand Court for a number of reliefs because they argued the refusal of their application to be married infringed rights guaranteed to them under our Constitution. In particular, their right to private and family life under Section 9, subsection 1 of the Constitution, of the Bill of Rights in the Constitution, their right to freedom of conscience under Section 10(1), their right to marry and found a family under Section 14(1), and their right not to be discriminated against under Section 16(1) of our Bill of Rights. To correct what they viewed as a wrong, they sought a declaration from the courts that the marriage law should be read and construed with such modifications, adaptations, and qualification as may be necessary to bring it into conformity with the Constitution. They had applied for a marriage license, so inevitably their legal proceedings were focused on marriage. However, Madam Speaker, of particular significance to this debate today is their claim that while they were entitled to marry, they sought as a minimum a declaration that provision should be made for them to enter into a civil partnership. Madam Speaker, honorable members would recall that the matter was heard by the Grand Court and the Honorable Chief Justice delivered his ruling in March of last year. The Grand Court ruled that the Bill of Rights in the Constitution did give Ms. Day and Ms. Bodenbush the right to marry. And by way of remedy, the Chief Justice ordered that Section 2 of the marriage law be amended to read as follows. Quote, marriage means the union between two people as one another's spouse, unquote. Madam Speaker, the Chief Justice also modified Section 27 of the marriage law to bring it into conformity with the amendment he ordered to Section 2. Section 27 is the section that deals with marriage declaration. In other words, Madam Speaker, the Chief Justice, in seeking to provide Ms. Day and Ms. Bodenbush with a remedy, legalized same-sex marriage in the Cayman Islands. That, Madam Speaker, remained the law until the Court of Appeals judgment, although the provision was stayed while the appeal was being pursued. So, Madam Speaker, this country has had same-sex marriage legalized here at that point. And I say that, Madam Speaker, is because we may, if we fail to pass this bill, arrive back there very swiftly. Madam Speaker, members will recall that the government then instructed the Honorable Attorney General to appeal the ruling of the Grand Court. At stake in the appeal was not just the substantive issue of same-sex marriage, but the principle that this House, not the Chief Justice, should write the laws of the Cayman Islands. And so if a law is determined by the courts to contravene the Constitution, then it should be for this House to have the opportunity to fix it. And so, Madam Speaker, on that basis, we pursued an appeal. On the 7th of November last year, the Court of Appeal delivered its ruling. And I'm sure that all of us in this House were relieved that the Court of Appeal disagreed with the Chief Justice as it relates to the right to enter into same-sex marriage in the Cayman Islands. The Court affirmed that under the current legal framework, marriage is only permissible between persons of the opposite sex. The amendments to the marriage law that the Chief Justice had sought to impose were struck down. On the face of it, Madam Speaker, this was a success for the government of the Cayman Islands. The court had granted our appeal, agreeing with our interpretation of the law and striking down the Chief Justice's attempt to change the legislation without reference to this honorable House. However, having delivered a favorable verdict on our appeal, the Court of Appeal went on to issue a declaration in absolutely unequivocal terms as it relates to the legal obligations of the Cayman Islands to put into law a framework to protect certain constitutional rights relating to private and family life under Section 9 of the Bill of Rights in the Constitution. Section 9, Madam Speaker, requires that the government shall respect every person's private and family life, his or her home, and his or her correspondence. In other words, Madam Speaker, whilst Ms. Day and Ms. Bawdenbush do not have a legal right to marry in the Cayman Islands, the court confirmed that they do have a right to private and family life, and as such, the right to a legal framework that is not marriage, but one that provides similar legal recognition and security. Madam Speaker, the declaration was not only unequivocal, it was robust and scathing. Members of this House should be in absolutely no doubt of this. I have asked that copies of the judgment be circulated to members, but I will read the exact language employed by the court. And, Madam Speaker, again, with your leave, I wish to lay a copy on the table of this honorable House.
So allowed, Honorable Premier.
Madam Speaker, members that have the judgment is being passed out now. I'll wait a moment. Thank you, Sergeant. Madam Speaker, the following excerpt is from page 36 of the Court of Appeals judgment. I am quoting directly. As we said in paragraph 6 above, the appellants have finally accepted, the appellants being the Cayman Islands government and the Legislative Assembly, that Section 9(1) of the Bill of Rights requires the Legislative Assembly to provide the respondents with legal status functionally equivalent to marriage. Its failure to comply with its obligations under the law in that regard is woeful. That it had such an obligation has been apparent for several years. As the Chief Justice set out in detail, the respondents, in broad terms, offer to compromise the present litigation on appropriate undertaking from the appellants to establish an institution of civil partnership. Even now, when during the course of argument, the court sought information as to what the appellants intended to do, we were merely told they were awaiting the outcome of the litigation. It is difficult to avoid the conclusion that the Legislative Assembly has been doing all it can to avoid facing up to its legal obligations. In the meantime, Ms. Day and Ms. Bush and their child suffer in the many ways the Chief Justice set out. In our judgment, a declaration in the following form is appropriate. In recognition of the long-standing and continuing failure of the Legislative Assembly of the Cayman Islands to comply with its legal obligations under Section 9 of the Bill of Rights, and in recognition of the Legislative Assembly's long-standing and continuing violation of Article 8 of the European Convention on Human Rights, it is declared that Chantel Day and Vicky Borden-Bush are entitled expeditiously to legal protection in the Cayman Islands, which is functionally equivalent to marriage. It is not appropriate to require undertakings from the Attorney General as is urged upon us by the respondents. Moreover, proper fulfillment of its legal duty by the Legislative Assembly should provide the protection sought. A final observation. We feel driven to make this final observation. This court is an arm of government. Any constitutional settlement requires the executive and the legislature to obey the law and to respect decisions of the court. It would be wholly unacceptable for this declaration to be ignored. Whether or not there is an appeal to the Privy Council in respect of same-sex marriage, there can be no justification for further delay or prevarication. Moreover, in the absence of expeditious action by the Legislative Assembly, we would expect the United Kingdom government to recognize its legal responsibility and take action to bring this unsatisfactory state of affairs to an end." Unquote. Madam Speaker, I said earlier that the principle at stake today is whether this House will uphold the rule of law. The Court of Appeal has challenged us clearly and directly to do so. As the Court describes, it would be wholly unacceptable for this House to ignore the Court's declaration and to refuse to act. Madam Speaker, how can this honorable House, how can members of this honorable House ask the courts to implement and enforce the laws we pass in this Legislative Assembly if we ourselves refuse to be bound by the decisions of our Court of Appeal? Indeed, Madam Speaker, how can we expect the people of these islands to be bound by the law if we, as lawmakers, refuse to do so? If we claim some moral right to ignore a very clear instruction from the courts, what is to stop every other participant in legal proceedings in these islands from doing the same? Madam Speaker, I have spent almost 20 years in this House. I have been proud to be a member. I have been proud to uphold the law and to observe the sacred oath that I swear, each of us swears, when taking office after each election. Madam Speaker, before taking up our seat in this honorable House, each of us is required to speak the oath of allegiance. Indeed, we cannot act as members of this House without doing so. And let me remind members, Madam Speaker, of that oath. I swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, her heirs and successors, according to law. So help me God. I will simply observe that the Constitution allows the words, "So help me God," to be omitted by members who wish to affirm. But I also note that the words "according to law" may not be omitted. That is the core of the oath we take, according to law. That, Madam Speaker, is how we must act as members of this House, according to law. Madam Speaker, increasingly I'm seeing and hearing calls for a people-initiated referendum on this matter, or from some in this House and outside of it, for a general referendum at the next election so that the public can decide on this issue. Madam Speaker, this is not a policy decision. This is a matter of law and indeed a constitutional matter. To repeat again, our courts are requiring that the Legislative Assembly provide the protections that they have identified. They are requiring that this Legislative Assembly cease the continuing breach of both Article 8 of the European Convention on Human Rights and Section 9 of the Bill of Rights of the Cayman Islands Constitution. The compliance with these provisions is not a matter of choice for this House or for this government. Compliance, rectifying these issues is a matter of complying with the law as articulated by the Court of Appeal. A people-initiated referendum does not apply to constitutional matters, and a general referendum, as allowed by Section 69 of the Constitution, is also not suitable to decide this matter. It has been decided by the courts, as I have just said, that this Legislative Assembly is in long-standing and flagrant breach of Article 8 of the European Convention on Human Rights and Section 9 of our own Bill of Rights. Some have argued that we can and indeed should continue to prevaricate. Why, some ask, are we rushing ahead with legislation when the matter is on appeal to the Privy Council? To answer that, Madam Speaker, I can do no more than repeat the words from the Court of Appeal. This court is an arm of government. Any constitutional settlement requires the executive and the legislature to obey the law and to respect decisions of the court. It would be wholly unacceptable for this declaration to be ignored. Whether or not there is an appeal to the Privy Council in respect of same-sex marriage, there can be no justification for further delay or prevarication, unquote. That, Madam Speaker, is why the government must proceed as we are doing today. Madam Speaker, honorable members should recall that the Court of Appeal was almost incredulous that despite having conceded the legal principle, the government had no plan, my government, the government which I lead, had no plan or timetable for legislation to enact domestic partnerships. We do not have to wonder then, Madam Speaker, what view the Privy Council will take if months later we go before them, as is the plan in February of next year, and still have no plans to resolve this impasse. Moreover, Madam Speaker, I ask that honorable members also recall that the appeal to be heard by the Privy Council is not about domestic partnerships or civil unions. It is about same-sex marriage. What is being appealed by the appellants there is the decision of the Court of Appeal, which found in favor of the government's and the Legislative Assembly's position that our Constitution does not require same-sex marriages. But, Madam Speaker, members must also recall that it has already been established and affirmed by the court that some form of domestic partnership or civil unions or civil partnerships, rather than same-sex marriage, is necessary to safeguard the rights of individuals such as Ms. Day and Ms. Borden-Bush. And that fact, Madam Speaker, will not change. It will not. And so if we fail to act, then the Privy Council will, I am certain, act in our stead and implement same-sex marriage, because there will be no other means of ensuring that the rights of persons in same-sex relationships are protected as are required by both Article 8 of the European Convention on Human Rights and Section 9 of our Bill of Rights. The issue before them is solely that, whether or not same-sex marriage is required under our Constitution. And if we do not have a domestic partnership law in place, then same-sex marriage will not be a difficult decision for them to make. And we in this House, Madam Speaker, will have only ourselves to blame. And many of those public voices now against this bill, despite whatever they say to you now, will hold us to account if same-sex marriage is introduced because we, this Legislative Assembly, fail to act. Madam Speaker, this is our moment of truth. This is our test of real leadership. We can act and have a hand in making our own destiny, or we can fail to act and dither and allow others to do as they see best. Madam Speaker, the circumstances over recent months with our response to the COVID-19 pandemic have caused a delay in bringing this forward. But as the court made its expectations clear, we should delay no further. We must act, and we must act now. There is also, in my view, Madam Speaker, added risk in delay. Notwithstanding any appeal to the Privy Council, the court made itself very clear that the protections sought by Ms. Day and Ms. Borden-Bush must be put in place. Again, I quote, "Moreover, in the absence of expeditious action by the Legislative Assembly, we would expect the United Kingdom government to recognize its legal responsibility and take action to bring this unsatisfactory state of affairs to an end, unquote. I can tell you, Madam Speaker, straight from the horse's mouth, that that stated expectation certainly caught the attention of the United Kingdom government. Some have argued that we should hold out against this change and let the UK impose it upon us. They seem to believe that in taking what they regard as a principled stand, that this would be a principled stand, and it is better for us to accept the change, refuse to accept the change, and have it forced upon us. Madam Speaker, I contend that that approach is not one of moral principle. And that it will not result in leading us into further delaying this matter. Rather, it would, in my view, equate to moral neglect to not seize the moment and act when we should. If we do not act, then this House is abdicating its responsibilities. But just suppose we do take such a course and delay. There must be an added risk that if the United Kingdom government were the ones to push a change, they would decide to impose same-sex marriage on these islands rather than domestic partnerships. It would not take very much. They can simply reinstate the ruling of the Chief Justice. He's even drafted the new provision for the marriage law for them. And many of those public voices now against this bill, despite whatever they say now, will hold us to account if same-sex marriage is introduced because we failed to act. There is, I think, a view that to accept domestic partnerships would be the thin edge of the wedge, and that same-sex marriage would be bound to follow. The experience in the UK and elsewhere in the world may indicate that there is some substance to that argument. However, Madam Speaker, same-sex marriage has come about in those jurisdictions because legislators in the UK and elsewhere voted for it. It was not imposed on them by the courts. I strongly believe that if we put in place these arrangements for domestic partnerships now, that gives us the greatest chance of keeping future decisions about same-sex marriage in the hands of future Caymanian legislators. And let me just say this, Madam Speaker. As the father of two 20-something-year-olds, 28 and 25, I can tell you, as I'm sure most of you know, the next generation of legislators will legislate for same-sex marriage. They have a very different outlook than our generation and the one that has gone before us. So let us leave it for them to decide. Let us not, in our dotage, sit back and be the subject of their criticism by saying they were not bold enough to do what they were elected to do. They let the United Kingdom legislate for them. And that is why we, who are the new legislators, have as little power as we do, why the UK still continues to control the narrative and the decision-making on key policy issues. Madam Speaker, as I've just said, the issue about whether or not same-sex marriage should be part of our legislation should properly be left to the future and the future legislators who follow us. Let us not preempt their ability to make that decision by our failure to introduce the domestic partnership law. Madam Speaker, as I have said, The issue for us is whether this honorable House will indeed uphold the law, whether we will put in place the legislation necessary to safeguard the rights of a section of our population who do not have those rights protected now. The courts could not have been clearer about their expectations of the steps that this House needs to take. There is one further risk I would like to highlight, and that is a political risk of inaction. This government, with the support of the opposition, has invested considerable effort in negotiating a range of constitutional amendments with the United Kingdom government. I have said before in this House that I believe these changes represent a step forward in our relationship based on the UK's view that democratic institutions and governance arrangements are maturing in Cayman, and that as such it is appropriate to give us more control over our own affairs. If we now refuse to act when obligated to do so by our own court, we would be demonstrating not political maturity, but adolescent irresponsibility. It would be hard in such circumstances to make the case to the UK that they should press ahead with the constitutional changes we have fought for and which were supported on all sides of this House. To be clear, Madam Speaker, no one on the UK side has yet threatened us with withdrawal of the proposed changes. There is no quid pro quo at play here. I am just realistic enough to recognize the risk and the consequent damage both to our much improved relationship with the UK and to our wider international credibility. It follows, Madam Speaker, that in the circumstances, the government has an obligation to give effect to the pronouncement of the court. The rule of law requires the government to do so. Indeed, both leading counsel from London who argued the case for us are quite firm in their advice that we should do so before the matter is dealt with at the Privy Council. It is for that reason that I am asking all members of this Assembly to support this bill. However, in so doing, I have assured those in my cabinet and on the government benches that they can vote their conscience with regard to this bill or not vote as they see fit. And I understand that the Leader of the Opposition has also told those on his team to do the same. It seems that may not be the case, Madam Speaker, and I may have been misinformed. So, but that's a matter for him, Madam Speaker. And I understand that I'm going to repeat that again. I won't. I have a good sense of who on my side supports the bill. And based on what they've said to me or said publicly, I believe I have a good sense as to who on the benches opposite will also support the bill. Of course, they may have changed their mind since last we spoke. And I will certainly see once I take my seat. But, Madam Speaker, I must commend one member opposite especially for his understanding that what is before us comes down to us doing our duty according to the law. But also, it will provide protection to the marriage law as well as providing legal protections to individuals like Ms. Day and Ms. Borden-Bush. I speak, Madam Speaker, of the member from Northside. In his public statements, he showed a clear understanding of what is at stake. In an interview to The Compass in November 2019, he said, "My fear has always been if we don't do what we want to do, the United Kingdom will do what we don't want to do, and that is tamper with our marriage law," unquote. Madam Speaker, this summarizes the position very well. I commend Mr. Miller for it. I commend him also for the strength of his conviction when he said in the same interview that if he would lose the election because of his support for civil unions, such as offered by the Domestic Partnership Bill, then so be it. He went on to say, and I'm quoting, Madam Speaker, "That's my position, and it is a considered position. That is not a flippant position," unquote. Again, Madam Speaker, whilst I wait to see how the member for Northside debates and votes on the bill, I certainly commend him for his publicly stated position. Madam Speaker, my good friend, the member for Georgetown Central, is what I shall refer to as a renowned fence sitter. I say this somewhat tongue-in-cheek. But on this matter, Madam Speaker, the member has certainly had his feet on one side of the fence or the other from time to time. But his statements to me personally and in the media does give the impression that he supports the bill. Madam Speaker, a story in Cayman News Service in an article on the 21st of July, that's not that long ago, noted that the domestic partnership bill will likely get the support from the two independent members, Ezra Miller and Kenneth Bryan, who have both said publicly that, quote, "It is better for Cayman to draft its own legislation to deal with this controversial issue than have it imposed," unquote, on us by the UK. Again, Madam Speaker, I completely agree with this sentiment, and I congratulate the member from Georgetown Central for taking that position. I will see, Madam Speaker, during the debate, which side of the fence my colleague from Georgetown Central will be on when he rises to debate. Madam Speaker, I am hoping that my debate here has successfully outlined the reasons why this House should vote in favor of and pass this bill into law. I hope, too, that I have sufficiently outlined the risks if we do not. Having asked members for that support, I will just, Madam Speaker, outline the main provisions of the bill, which reflects substantially the arrangements which obtained in Bermuda following their Domestic Partnership Act 2018. As usual, Clause 1 deals with the short title and commencement. Clause 2 with a number of relevant interpretations, including that of domestic partnership, which means a domestic partnership formalized and registered in accordance with the law. Clause 3, Madam Speaker, is of particular significance in that it contains an overview of the eligibility to enter into a domestic partnership. In particular, it stipulates that two persons over the age of 18 may enter into such partnerships. However, it also provides that persons 16 years or older, but not yet 18, may also enter into such a partnership, providing there is parental consent or consent from a legal guardian or the court. The clause also stipulates that if persons are already married or involved in a domestic partnership or an overseas relationship, formal relationship, they would not be able to enter into a domestic partnership in Cayman. Similarly, Madam Speaker, neither of the persons participating must be in the prohibited degrees of domestic partnership, that is, must not be related as siblings, child, parents, etc. The same prohibitions which are obtained with respect to marriage. In essence, Madam Speaker, if there are no legal barriers or caveats, sorry, Madam Speaker, I missed a paragraph. Madam Speaker, clauses 7, 8, and 9 together deal with the issue of notice and issuance of licenses for domestic partnerships. In essence, Madam Speaker, if there are no legal barriers or caveats, then the registrar is required to issue the requisite license once the required notice period has been met. There is also provision for a special license to be issued by the Deputy Governor. Part 4, Madam Speaker, which covers clauses 14 and 15, speak to the formalization of a domestic partnership. It provides that once either the registrar or a domestic partnership officer is satisfied that all the necessary legal preconditions have been fulfilled, they may formalize the relationship. The formalization will take place in the presence of 2 or more witnesses. It should be noted that it also contains provision for what is called partnership in extremis. That is a type of deathbed partnership where, in the opinion of a medical practitioner, at least one of the parties is in a dying state but is still able to comprehend the effect of entering into a domestic partnership. Madam Speaker, a feature of the bill is the ability of a person who has any lawful grounds to object by way of a caveat to the issuing of the license for the domestic partnership. Once an objection is lodged, it has to be recorded by the registrar and eventually transmitted to a judge of the Grand Court for an administrative decision as to its merits. If the caveat is upheld, the partnership cannot go ahead. Madam Speaker, Part 6 of the bill covers issues such as when a domestic partnership may be said to be void or voidable, including instances where there is a lack of legal capacity by one of the parties to the relationship. Madam Speaker, also of significance is Part 7 of the bill, dealing with the formal registration of a domestic partnership. Clause 21 in particular contemplates that the Registrar General shall maintain a register of all civil partnerships, including all notices given and all the domestic partnerships entered into under the law. Clauses 25 to 27 cover matters dealing with appointment by the Deputy Governor of Domestic Partnership Officers and for the list of those officers to be published by the Registrar General. Madam Speaker, it is worth emphasizing that according to Clause 29, a person who is a marriage officer is not permitted to formalize domestic partnerships unless that person is also expressly appointed as a domestic partnership officer. Of equal significance, Madam Speaker, is the fact that a marriage officer cannot be forced to use any place of worship under his or her control to formalize a domestic partnership. Hence, Madam Speaker, the reason for the caption, Protection of Marriage Officers, at Part 10 of the bill. Madam Speaker, like the issue of the ability to permit gambling on Cayman registered vessels in international waters, the issue of the ability to formalize domestic partnerships has also been mooted for some time. You may recall, Madam Speaker, that the gambling issue has been resolved with an amendment to the gambling law in 2016. Part 11 of this bill seeks to address the granting of license by the Honorable Deputy Governor to the master of a Cayman registered ship to be a domestic partnership officer and thereby facilitating formalizing of domestic partnerships aboard such ships on the high seas. Madam Speaker, in Part 12 of the bill are provisions that will, among other things, allow for the recognition in the Cayman Islands of certain overseas relationships to be treated as domestic partnerships. These, Madam Speaker, are relationships that are either specified in the bill or sorry, Madam Speaker. Sorry, Madam Speaker. I'll read that paragraph over. Madam Speaker, in Part 12 of the bill are provisions that will, among other things, allow for the recognition in the Cayman Islands of certain overseas relationships to be treated as domestic partnerships. These are relationships that are either specified in the bill or having met certain other general conditions and that are registered in the relevant overseas countries. For these, Madam Speaker, I would ask members to refer to Schedule 2 of the bill, where both the countries and the description of the relationships are listed. Another feature of the bill is found in Part 13, which stipulates that in instances of breakdown and dissolution of a domestic partnership, the provisions in the matrimonial causes law and the maintenance law would apply to their court proceedings. Then, Madam Speaker, there is Part 14 of the bill, which creates certain offenses to do with domestic partnerships. For example, a person who, not being a registrar or a domestic partnership officer, purports to formalize a domestic partnership. There is provision in Clause 45 for the publishing of annual reports of summary and domestic partnerships registered during the year. Then, Madam Speaker, there is Part 16 of the bill, which allows for references from other laws to be applied to domestic partnership. And for details of this, Madam Speaker, members can see the column in Clause 46 for that list. Part 17, Madam Speaker, seeks to, among other things, clarify the position as it relates to marriage, but also goes on to provide that certain overseas same-sex marriages may be recognized if entered into before this bill becomes law. Also, Madam Speaker, there will be a slight committee stage amendment to, among other things, provide that thereafter such marriages can only be recognized and treated in Cayman as domestic partnerships in certain circumstances. So, Madam Speaker, that is a general outline of the main provisions of the bill. It is not an exhaustive summary, given the length of the bill. Additionally, Madam Speaker, I should advise members, honorable members, that if this bill becomes law, there will be a number of other bills following to give effect to certain consequential changes to other laws in order to give full effect to the declaration of the Court of Appeal as it relates to, quote, functional equivalency to marriage. These, Madam Speaker, include laws such as the Penal Code, I need something stronger today. These, Madam Speaker, include laws such as the Penal Code, the Mental Health Law, the Immigration Law, National Pensions Law, the Adoption Law, the Succession Law, the Wills Law, and indeed some others. In closing, Madam Speaker, I would like to take this opportunity to thank the Attorney General and his staff for the tremendous work they have done to produce this bill. It is a necessarily complex piece of legislation, given the requirements laid down by the court and the need to ensure we can demonstrate that the resulting legislation reflects the needs to safeguard the constitutional rights of those who were not previously offered such protections. Madam Speaker, in asking members to vote to pass this bill, I am asking them to uphold the rule of law and the principle of respect for the decisions of our courts. I know this is a difficult decision for some, including some of my colleagues on the government benches. However, Madam Speaker, there is no place for us as lawmakers to hide. Either we accept the rule of law and make the changes we are bound by our oaths of allegiance to make, or we do not. There is no middle ground. The idea that we might simply sit on our hands while either the Privy Council or the United Kingdom government solve this for us is at best to abdicate responsibility, and at worst to fail in the most fundamental tasks of government, to uphold the law and to safeguard the rights of our people. Madam Speaker, this is now a question of political leadership. Are we, as lawmakers, going to face up to our responsibilities, or abdicate them and leave it to the Privy Council or the United Government to discharge the sacred function that we swore an oath to do? Are we prepared to bear the burden of leadership as we were elected to do? Or shall we leave it to the United Kingdom, either by virtue of their judges in the Privy Council or as a result of the extension of an order in council to these islands to make the decision which each of us in here campaigned that we were able and competent to do. That, Madam Speaker, is the question which each of us must ask ourselves. There is a reason why it is called the burden of leadership. It is often heavy to bear. We shall see, Madam Speaker, whether we are capable of bearing that burden or whether it shall cause us to bow and pass that responsibility to another country and other people to discharge.
Does any other member wish to speak? Does any other member wish to speak? Call on the Honourable Leader of the Opposition.
Madam Speaker, thank you. It appears to me like the Premier has some pretty good speech writers. But that's not to take anything away from him, from his ability to speak off the cuff either, you know. Madam Speaker, Premier is right. He and I got elected before him, but he and I were sworn in on the same day, and he was sworn in front of me. So he thinks he has won the day with time. Never forget it. Mine was 11 o'clock on November the 8th, 2000. And his was the next morning, on the 9th. And when we were sworn in on the 15th of November, because Georgetown a little bigger, he went and got sworn in. He was sworn in before me. So we have been here, both of us have been here around the same time. Madam Speaker, on December the 8th, 1941, the then President of the United States of America, Franklin Roosevelt, while addressing both political arms of that country, seeking a declaration of war, he started his address with the following famous words, and I quote, "Yesterday, December the 7th, 1941, a day which will live in infamy. The United States of America was suddenly and deliberately attacked by naval and air forces of the Empire of Japan," unquote. Madam Speaker, I believe while our country has not come under any war attack, we can safely say that today is a date that will long be remembered by generations to come. Be it in favor or against the acts of this government, and rightly so. Madam Speaker, let me now set the record straight for the Premier and his government and the general public. Pardon me. My contribution to this domestic partnership bill will generally reflect my personal views, and in some instances, not necessarily the views of the members of this opposition. This matter is of such social and moral values to all that they will express their own position thereon. And as this country knows and has come to appreciate, they are very capable of freely expressing themselves. Madam Speaker, like the Premier, I cannot recall one instance in the nearly 20 years since I have been a representative within this august body that there has been a more divisive bill promulgated by a government to come to these hallowed halls. The Premier calls it contentious. That is an understatement, like he said earlier himself. I think that despite the Premier's position that rule of law is what this is about, it might be that the government should withdraw this bill and allow this country time to come together and have a chance to be consulted and be informed on the matters that the government is trying to achieve. Madam Speaker, that I know will come with a opposition thereto by saying this has been a matter long outstanding, therefore it has been ventilated within our community. I am here to say that I do not think that is true. Let me briefly touch on some of what has caused such division in our society. Madam Speaker, the government gazetted this bill on June the 26th and announced they were seeking public input in parallel with the gazetted bill for 30 days. Now, Madam Speaker, the Constitution requires the government to gazette bills 30 days and 21 days in advance of them being presented to this honorable House. As a matter of fact, I think the new proposed changes to the Constitution will increase that up to 28 days. And I will touch on the changes to the Constitution a little bit further on in my debate. Madam Speaker, I'm sure the member from Georgetown, West Bay Central, Cap as well, West Bay, West Bay Central. And the two members from Cayman Brack, and the Premier, and myself, and my good friend from Savannah will know that this is the first time in 20 years that I've seen that done. I've never seen a consultation period during a gazetted period, gazettal period. Never. It is customary, not only in this country, but all countries where there is so-called democracy, that when a government is proposing legislative actions or reform, that they circulate in what is termed a white paper. For a period of time prior to the introduction to the legislature, parliament, whichever you wish to call it. This was not the case. In England, a white paper sometimes can last 6 months, a year. I've seen them here last more than 2 years. And, Madam Speaker, when I say white paper, I should have brought the one that England put out for the overseas territories in 2015. That was white paper. It might have been done in color, but it's called a white paper. That's what it's called, white paper. I've never seen this done before. Madam Speaker, the government action in this case indicates to me that they had no intention of, one, taking consultation, seeking input, accepting input, and changing the intended course of action. None. Indeed, Madam Speaker, if the government's intentions were genuine, they would not have gazetted the bill with the consultation period. Madam Speaker, to the best of my knowledge, only a few members of the government, to the best of my knowledge, only a few members of the government made any attempt to consult the people and take input. If they had, despite the Premier's lengthy delivery about rule of law, we wouldn't be here today. We wouldn't. Madam Speaker, I understand the rule of law too. Maybe not as proficient as the Attorney General and the Premier and the Minister for Education and the Minister for Financial Services. But the one good thing that the Attorney General will tell you about me is that I read and I understand. That I know. But Madam Speaker, with the rule of law and leadership also comes the concerns that your citizens have. Madam Speaker, when the port project was something that this government was convinced was in the best interest of the people, and this was leadership, and they had to convince the people that this was what they needed. And when they needed the support, they spent the people's money to promote an ill-conceived project. An ill-conceived project without batting an eye. But when something as divisive, contentious, the Premier has said, the port project may have become contentious, and I agree with that, but it was a particular cause by a particular set of people that set out to make sure the government was not going astray. Yet, as sensitive as this matter is, and we are here today with a bill that is contentious, divisive, that was only made known to the public on the 26th of June. My view is that that's trying to railroad through legislative reform. Now, I don't know why that was done. All I can say is that that caucus over there, this is in their arena. It's not mine. If a price has to be paid for this, it rests right over there, not here. For circumventing, maybe deliberately so, I don't know. What is a reasonable process in this country? A process that is, that in itself has moral obligations on us to notify our people. That in itself. Don't we want to hear from them? Does this government think the people of this country stupid? I keep telling people, if you think the intelligence of this country is concentrated in here, go out by the waterfront. Go out by the waterfront. They know more about running this country than the 19 was put together do. They know what they want. They know exactly what they want, but more importantly, what they need. But, Madam Speaker, I say to this government, I warn this government that they should pay more attention to the silent majority. The Premier knows that. I don't know how many others out there know that. They too are speaking, despite the silence. The Premier knows that the one thing we can depend on is that Caymanians speak loud and clear when they believe or when they feel they're being trampled upon. when they feel they are being disrespected. Madam Speaker, I have nothing against the government bringing a law here, a bill here, to pass into law. But the people must be consulted, man. I know there are times that we have to make decisions, and I have been on that side of the road myself. But something that touches everyone of this nature, you can't at least try to consult with them, as many as possible. Madam Speaker, we the opposition, despite the difficulties due to the restrictions through the COVID-19 regulations, made every effort to consult with people on this issue. For me, I distributed 300 flyers, which meant every household in East End received one. I utilized some aspect of social media also. I delivered copies of the bill at my expense upon request. I can assure this honorable House that I got many responses. And I can further confirm that the overwhelming response was not in favor of supporting this bill. Now, I don't know, different constituencies or demographically made up differently in any country you go in. And in the western end of the island, I would hazard a guess that is much different from Cayman, Little Cayman, and East End, Bordentown, North Side. Much different. Maybe on that end, an exemption would be North Side, but within those districts. We make every attempt to consult with our people. Madam Speaker, I met with the management of every church in East End in one meeting. And along with the members of the opposition, I also met with the executive of the Ministers Association. And I too received a letter from them. So if the Premier reads one of support, then the one I receive is supporting us, not supporting it too. Now, if we talk about contentious and divisive, we need to also talk about confusion. Madam Speaker, no, Madam Speaker, we have to understand how contentious, how disruptive, the kind of problems this thing has caused. The one addressed to the Premier is dated July the 16th, Thursday, July the 16th. Mine is dated July 20th. Dear Mr. V. Arden McLean, I take this opportunity to share with you from the executive of the Cayman Islands Association our concerns regarding the above bill, Domestic Partnership Bill. We are aware of the desire of the part of lawmakers to ensure that our laws respect the rights of all persons. We believe, however, that our laws should reflect the directives of the Supreme Lawgiver. These directives are found in the Bible through a book of great iniquity, yet it forms, though a book of great iniquity, yet it forms the foundations of our laws. The Domestic Partnership Bill do not state it explicitly, clearly makes provisions for same-sex relationships. This, of course, is in keeping with the recommendation of the Court of Appeal. We believe that making provisions in our laws for these relationships run counter to the teaching of Scripture and that it is not in the best interest of the well-being of our islands. Please find attached enclosed 2 documents for your consideration as you decide on this important matter. Thank you, yours very truly, Torrance Bob. Madam Speaker, so what I'm saying is in a matter, you're going for lunch?
Yes. Honourable Leader of the Opposition, can you share that letter with the members, or a copy of that letter from the Ministers' Association? The one that was addressed to the Opposition? Dated.
Well, I didn't have the Premier one either, despite him saying that I had it. And I'm glad he shared it with me, and I certainly will, but Madam Speaker, if we compare both, we'll see that the same person signed it, and the seamless scribbling for a signature. Madam Speaker, the position paper that he referred to therein quite lengthy, but and it's titled Domestic Partnership, doing what is right for the right reasons. Formal position letter written by the Cayman Ministers Association. Oh, it was? Okay. As we in Cayman continue to grapple with the contentious and divisive issue of sexuality and gender, in this case framed in the terms of Domestic Partnership Bill, let us be aware of some of the pitfalls that have been strategically placed before us, in particular before Parliament. For it is ultimately our elected representatives who have to run this obstacle course. The first alarm that must sound is for us to discern reality from illusions. The reality is that our Christian heritage and worldwide view clearly hold love as the ultimate ethic behind our actions. However, we must not allow our concept and application of love to be reinterpreted by secularists, especially those who have rejected the truth expression in the Scriptures about the sacredness of sex and marriage. In particular, if we are to be guided by the biblical ethic of love, we must start first with what the Lord Jesus said was the first and greatest commandment, to love the Lord our God with all our heart and with all our soul and with all our mind. The second is like love your neighbor as yourself, states Jesus. This is not just a sequential arrangement, but a prioritized arrangement. We must begin by loving the Lord God before we can understand and apply the second, loving our neighbor. Clearly, it's not possible to love the Lord without respecting, loving, and keeping his commandments regarding the sacred character of marriage, and therefore the sacredness of sexuality and sex. The first divine purpose for marriage is that it was ordained for the increase of mankind according to the will of God, and that children might be brought up in the fear and nurture of the Lord, and to the praise of his holy name. If making a decision about the current domestic partnership bill is to be guided by this ultimate ethic of love, and we, the public and our legislators, must not fall into the trap of conflating love with approval. Love acts in the best interest of others and not merely to meet the wishes or desires of those who care about or are responsible for. To say yes to this bill and then defend one's position by an appeal to love may give the appearance of taking the moral high ground when in reality it may only be doing what is circumstantially expedient. This leads us to identify the second trap we must avoid: equating desires and rights. The current scenario representing a seismic shift in Western morality has resulted in legislators and courts seemingly accepting the default position that a desire, whether or not seen to be in the higher levels of the hierarchy of human needs, must be catered and reframed as a right, sometimes without sufficient or any consideration of the pressing needs of others affected with vulnerable parties or the long-term good of society. Drawing upon the biblical ethics of love and morality, we acknowledge that human desire is the worst possible foundation for determining public and private morality. What is good, both for the person and for the community as a whole, old and young, adults and impressionable children, does not answer to the demands of fleshly passions, but rather must answer to the question of what is truly right. This is the real issue. And this is the criterion that every member of our parliament must apply as they engage their hearts and minds fully in this exercise. Again, our appeal to both the public at large and our legislature is that we do not conflate rights with desires, nor conflate love with approval. It is important to avoid confusing the love expressed in the scriptures with secularism's counterfeit version of love. Doing what is right for the right reason, regardless of the consequences, is a fundamental biblical approach to all of life. This is our appeal to you all. So, Madam Speaker, as you can see, I don't believe that these people are necessarily doing anything here out of hate. Madam Speaker, they are expressing what was made clear to me with the consultation that I did. That while people are generally accepting of people who are of a different sexual orientation, they do not support same-sex relationships legislated in their country. Which is whether it's marriage or anything similar to marriage. And Madam Speaker, like that letter, what was also made very clear to me was that this opposition, if you want to call it that, to it is based on moral and societal norms. It is not born out of hate. But I should pause here, Madam Speaker, and talk about the Premier saying that we must be respectful. I see the Human Rights Committee wrote about being respectful in our debates. Really? 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 Who am I to be chided about my debate when we're not doing it to anyone else who would have a different view than I may have? Madam Speaker, I believe that the concerns that many of the people who call me and express their opposition to this, their view, the concerns they have is this is alien to them. But what is foreign, most of all, and I use that term, and quoted, in inverted commas. Foreign mean not being from this country in the past. Is the in your face by those who have a different view. But when those of us, if I can lump myself in that or anyone else in here, who has a view, then we're criticized. We're nailed to the, well, I gotta be careful with that because that's probably what you get. You're nailed to the cross. You're persecuted. I am here debating this, and I'm not bashing anybody. But these are the realities of what is happening in this country. Madam Speaker, this is going, God forbid, to get worse. I hope we have a way of dealing with this. I really hope we do. Because I've never, personally, I've never bashed anyone. I saw Miss Day the other day in the supermarket. Of course I spoke to her. It's not my business. It's really not my business. I have often said in 1999 when the provisions for decriminalization of homosexuality in this country was raging. I said then, and I said since then, and I've subsequently said it, and I say it here again today. For a country to run properly, The government needs to stay out of people's bedroom. Okay? We need to stop going in people's bedroom. But we love to think that that is our job. The fact that burglary was a criminal offense in private means that you could break down the doors of people's homes and go in and prosecute them. When you couldn't do it with heterosexuals. So when they decriminalized it, Madam Speaker, if you will recall, and others who were following that, I know the Premier and I were, because we were gearing up to take on somebody at the polls. There was no debate on it in this country because England saw it as an encroachment on those people. Now there is a debate on this matter, a contentious debate. Therefore, I believe that additional consultation needs to be made. And I know the Premier went through all this about the courts, and I could touch on that in a little bit too. And how they instructed the Attorney General, the government. I hope people don't think that when he said the government now, that's all of us in here included in that. He was merely talking about the executive, which is him and his 6 other executive members. I wonder if he deliberately left out that it was myself who moved the motion and seconded by the member from Savannah. Well, I don't know if Cabinet already took the decision, but it wasn't said here. But Parliament, the executive is enabled by Parliament. And I can tell you when Parliament says that's what they want done, that's how it works. Unless you're prepared to do otherwise and become a dictator and say no. Or you all were happy for me to get up here and beat up Chief Justice. Madam Speaker, the one thing that people must understand is that this government likes the sanctity of separation of powers. So do I. And we can come into that one too. Madam Speaker, this consultation with our people and stuff doesn't seem to be one of the ideals or one of the principles or one of the policies of this government. Madam Speaker, I said here recently that this is a constitutional democracy and not a parliamentary democracy. But it appears that those who understand that, who understands the difference, are drunk with power and do as they please. And those who do not know the difference is following with glazed eyes and do not have the gumption to question the actions or behavior of their leaders. That, I submit, in itself is a travesty to this democracy. That is a travesty. Of sitting while sitting in this legislature. When we allow individuals or entities to define how we represent our people and define who our future, what our future is, then that's entirely up to you all, whomever wishes to do that. I do not wish to define people's future, nor their ability to represent their people. Each of us here, not two of us, had our name down on the same ballot paper. Not two of us. Each of us is an entity, a person unto our own, unto ourselves. Given the responsibility to lead, politically lead your constituency first, and then generally your country. If you want someone to lead you into the abyss, and that is what your legacy will be, then feel free. I know what mine's going to be. I know exactly what mine is going to be. Mine is going to be that I died while standing on my feet and not begging on my knees. That's what mine will be. And it matters not to me what they put on my headstone. I'll come up and know what it is.
Honourable Leader of the Opposition, I will now suspend the House for lunch, and I'll ask all members to return to the chamber promptly at 2:30.